sorry.
John, you're distracting one of our speakers, but I suppose you get a little poetic license today. The, you know, it's become a trite reference when you are the wind-up panel and you're bringing the whole thing home to say that we saved the best for last. As it happens every now and then, it's actually you know, more or less true, and this is one of those occasions where we've got an absolutely phenomenal group of speakers on a topic that, as you've been hearing at the last session and earlier, is a theme woven throughout both much of John McCamus's work and certainly much of today, and set the stage in a sense for why we wanted to save access to justice as the exclamation point on which to conclude what's been a very thought-provoking and fun day. And the snow is swirling a little bit, but it's not threatening. It's just beautiful scenery for the moment, so don't worry. Exactly. So my role, as with the other moderators, is a happy one of doing some brief introductions and then just steering the speakers to keep their eye on the clock as well. We have three speakers who all have devoted a substantial portion of their recent scholarship and scholarship dating back a number of years to this question of access to justice, but in very concrete and different circumstances, because it has a quality about it that can stifle debate. No one's against it, everyone's for it. No one can make it happen alone, so it's easy to call on others to do things, and it, of course, never will be perfected, so it has this eternal quality to it. But what unites the three speakers, Janet Mosher and Trevor Farrow giving what will be the core papers, and Michael Trebilcock doing the role of the discussant, what unites them is an empirical resonance. In other words, all three, in their earlier work and certainly in their discussion today, are really interested in that blend of good principle and good theory, but also a real attention to lived reality. And that is what distinguishes, I think, the very best work in this field, and certainly what John McCamus's work over the years, particularly in the reviews around Legal Aid Ontario that he's spoken about and mentioned last night at dinner, have revolved. So Janet Mosher will start, and her talk will be on access to justice amid threats of contagion, and she is building on a really ambitious multidisciplinary work of which she's contributing a really interesting part, and it sounds like that's always how I describe Janet Mosher's work. She doesn't take on projects except the really ambitious multidisciplinary ones in which she gets to work on really interesting issues with really interesting people and results that are always informative and original. Trevor Farrow, who's also on faculty here at Osgoode, and some of you will know is himself steering exactly one of those ambitious multi-year, multidisciplinary enterprises on the costs of justice, will be speaking on the deeper question around what access means, and in particular what people think it means. And this came up in the last session on civil liberties. What do people think about the Charter and our rights? And again, the empirical challenge of how to find that out is a fascinating aspect that Trevor will speak on. Michael Trebilcock, whose own work in legal aid reviews has dovetailed with John McCamus's, and of course also has written separately and provocatively on access to justice and understanding everything from legal needs to the innovative ways to harness the market and the public interest together to address it, we'll discuss. So without further delay, let me ask you to welcome Janet Mosher to kick this off.
Thank you, Lorne. And I also want to start with a particular note of thanks to John. The interesting multidisciplinary research projects that Lorne alluded to that I've participated in have very often been as a result of John's invitation to participate. So thank you, John. The first invitation goes back to about 1995, seems like yesterday. The Civil Justice Review that John was undertaking as chair of the Ontario Law Reform Commission, commissioning a number of background research projects, studies for the Civil Justice Review, and he and the other commissioners had identified that an important area for investigation was access to justice for disadvantaged groups, and commissioned myself and Ian Morrison to do that research. More good fortune came my way when John invited me to prepare a background paper on poverty law legal services for the Ontario Legal Aid Review, more widely and fondly known as the McCamus Review. A review which guided John and those he worked with, including, importantly, Michael Trebilcock, to a series of well-documented, thoughtful recommendations for significant changes in the structure and administration of legal aid in Ontario. Beyond these major reform initiatives spearheaded by John, and you've heard about many of his other initiatives, I want to note the incredible time, dedication, and stewardship he's devoted to legal aid since becoming chair of the board. And this tells us that John's interest in enhancing access to justice extends beyond the academic and the conceptual. Rather, he's a person who's taken ideas and concepts and given them traction in the real world. He's helped to breathe life into those ideas day in and day out. So I see this afternoon as a third opportunity John has created for me to continue the ongoing conversation about access to justice, especially for those who experience profound social marginalization and vulnerability. But the context in which I want to explore access to justice is an entirely new context for me. I feel quite like a beginner here, so I look forward to your comments and questions. But the context is one of pandemic planning, and thus the title of the paper, Access to Justice Amid Threats of Contagion. And like the background work for the Civil Justice Review, the Legal Aid Review, this work reminds us that the frontier of access to justice is never static. Not only because social relations and forms of social regulation are constantly evolving, but also because of how we conceptualize access to justice. As Roderick MacDonald's work has illustrated so clearly, how we understand a concept of access to justice is always and perhaps inevitably contested. So a wee bit of background to situate this work, and Lorne has referred to it briefly. This arises out of two much larger projects on pandemic planning and homelessness, involving a number of academics from a variety of disciplines. So far, more than 350 homeless people across the country in 7 cities have been interviewed, as have service providers and public health officials. And my role, so this is a work in progress, is to connect what we're learning from those interviews with existing and emerging legal frameworks, and to think about how access to justice might inform our thinking about those legal frameworks, or more broadly frame our approaches to pandemic planning. Now, pandemic planning has long existed, but it's emerged with a new vigor post-SARS, and fueled by the events of 9/11 and then by the threats of bird flu and swine flu. Now, in the literature that I've read to date, one of the things that has really struck me is the emergence of two broadly competing meta-narratives, or two different stories. And I have to say, in working on this, I've been influenced by the work of a brilliant storyteller, Thomas King. In his Massey lectures of about 2003, 2004, he talks about the power of stories and the difference it makes which story we choose to tell. And so here I see there are two profoundly different stories, and which story we choose to tell has really important ramifications for persons who are homeless and socially vulnerable, but they also have profound implications for all of us. So the first story, this is a story provisionally entitled National Security in a Threat Environment. Okay, so this is a story in which a central analogy is drawn between contagious disease and terrorism, between the need to identify, control, and contain the individual carrier of disease and the terrorist intent on destruction. It's a story in which surveillance, borders, containment, control, and individual responsibility are central to the storyline. And the moral of this story, it drives us almost inevitably to this conclusion is that we must sacrifice individual rights to liberty, mobility, security for public health, reinscribed as national security. Now, central components of this story are found, for example, in Canada's 2004 national security policy. I quote, "Terrorism is a global challenge that has been recognized by the United Nations as a crime against humanity. Canada is not immune to this threat, but the threats we face are not limited to terrorism." The SARS outbreak demonstrated the power of individuals to unintentionally transmit threats around the globe at the speed of air travel. The government is determined to pursue our national security interests and to be relentless in the protection of our sovereignty and our society in the face of these threats. It cautions you and I, the world is a dangerous place. Even if the relative safety of Canada sometimes obscures just how dangerous it is. So the policy renders the risky and threatening environment as taken for granted, a matter of common sense, and cautions you and I not to be lulled into complacency by the relative safety we may, in fact, temporarily experience. So as many others have observed, this approach collapses acts of terrorism, failing states, pandemics, and a range of other threats into a singular, all hazards approach, and embeds all these threats within a framework of national security. As a number of American public health scholars have noted, what's emerged there, and I would say is emerging here, is a new paradigm in public health, where public health emergencies are seen under the intensive spotlight of national security concerns. Now, individuals carrying disease or indeed even exposed to disease become like the terrorists, enemies of the state, to be surveilled and contained. They are, in effect, recast as non-citizens and actions against them necessary, as Canada's security policy states, and I quote it, to protect Canada's sovereignty. There's a preoccupation then not only with securing the borders of the nation state, but securing internal borders, constructing borders around the individual to contain them. Now, the choice of legal framework within this narrative is one that expands the ground for conducting disease surveillance and the control of movement through quarantine and other social distancing measures. I won't bore you with the details of Ontario's Health Protection and Promotion Act, but I would say it largely reflects this framework. So, for example, a medical officer of health has the power to order a person who has or may have a communicable disease or is or may be infected with an agent of a communicable disease to submit to an examination by a physician, place herself under the care and treatment of a physician, and if that disease is virulent, which is defined by regulation, order that she conduct herself in a manner not to expose another person to infection. During the SARS outbreak, the legislation was amended so that the medical officer of health could issue an order against a class of persons, class not defined. Now, the person who is the subject of an order has a route to have that reviewed. The medical officer of health has an entirely different procedural route to enforce such orders. A court can ultimately order a person detained, examined, and treated, detained up to 6 months. That can be reviewed for further 6-month periods. And the orders of the medical officer of health and of the court override provisions of the Healthcare Consent Act, which would otherwise require consent to examination by a physician, to detention, consent to treatment. Needless to say, such orders reflect extraordinary exercises of power. So what might we say about this legal framework if we were to evaluate it through an access to justice lens? So one account of access to justice, which in other writing I've called the legal professional account, an account of access to justice that is really focused on access to dispute resolution, institutionalized dispute resolution. If we were to apply that lens, we could identify a quite familiar catalog of barriers to access to institutionalized dispute resolution. And indeed, the Campbell Commission, investigating SARS in Ontario, identified a number of access to justice gaps. I'll go through these rather quickly. Delay. Time periods set out in the legislation are such that in the context of a pandemic are absurd, longer than any likely period of quarantine or isolation. Complexity. The Campbell Commission said the present law, and it's pretty much the same now, presents a confusing maze of overlapping and uncertain judicial powers and procedures best described as a legal nightmare. Complexity contributes to delay, but also it means that procedures are difficult for most people to navigate, including, when learned through the testimony provided during the SARS Commission, difficult to navigate for public health lawyers. Lack of access to counsel. How is one to navigate the system without access to counsel? And there are grave issues at stake. Participatory rights. How do we think through participatory rights in the context of a pandemic? Now, as I mentioned, the Commission identified a number of these gaps in access to justice. Not one of these has been subject to, not one of those recommendations relating to filling those gaps has been implemented in Ontario. Rather, the only changes have been the expansion of powers of the medical officer of health, that is to issue the orders against classes of persons, expanding the jurisdictional reach of police to enforce such orders, and expansion of places of detention from hospitals to any appropriate place. So in Ontario, we have a regime in which a person, or indeed an entire class of persons, can be ordered detained and medically examined without consent and required to behave in a manner not to expose another person to infection. Notwithstanding these significant infringements of rights to mobility, bodily integrity, security, and liberty, the procedural opportunities to challenge such orders are woefully inadequate. So this might lead us to the conclusion that renewed vigor is required to fill these access to justice gaps. We need to simplify procedures. We need to create appropriate timeframes. We need to guarantee access to counsel. Now, I don't want to suggest that those would necessarily be bad measures, but measures of this sort leave the central storyline firmly in place. And this, I want to suggest, is deeply troublesome. And there's 2 points I want to explore here. First, I want to suggest, and I alluded to this at the outset, that the central storyline itself poses enormous limits on our capacity to effectuate even these limited access to justice reforms. And secondly, I want to say that the storyline has negative implications for the homeless and vulnerable and for all of us. And that what we need to be looking for is a counter-narrative, a second story, one that I'll come to in just a moment. So let me just develop the first point, the central storyline, making it impossible or really difficult to effectuate even the limited kind of access to justice reforms identified by the Campbell Commission. So given the dominant narrative of the story, persons harboring disease or even potentially harboring disease are cast as the enemy of the public. They're the villains in the story. And what is to be saved as public health or national security is the outcome of the often described delicate balancing of individual rights and public health, not already largely predetermined. The narrative pull of the story leads us to the conclusion that individual rights must give way to national security. So I think that the capacity of access to justice, understood as access to institutionalized dispute resolution, that is attending to issues of delay, cost, complexity, legal representation, is starkly limited by the overwhelming power of the meta-narrative. Indeed, that the Ontario government has failed to act on the recommendations of the Campbell Commission is a disturbing signal of just that. So let me turn to the second point, which is the deeply problematic implications of the storyline, and to do that by talking about the counter-narrative or the second story. And I was struggling with what to call this second story, and after listening to Roderick MacDonald, I've got a title for the second story, legal pluralism, or a legal pluralistic approach to law reform. And as he was speaking, I saw lots and lots of resonances and connections between his story and this story. So at the core of this second story is justice, and in particular the fair and equitable distribution of benefits and burdens. This distributive concern finds no place in the national security narrative that reduces individuals to risks, demonizing them in the process. In the second story, individuals appear as persons with diverse needs, differentially situated in their ability to access resources. The central motifs of this story, voice, participation, trust, and the fair distribution of burdens and benefits, are woven throughout the account. And a point to which I'll return in a moment, it's a story that I think resonates strongly with non-instrumental conceptualizations of access to justice. So rather than identifying individuals infected with or exposed to disease as threats requiring containment, the story focuses on our interconnections and our mutual obligations. It draws connections not to other threats, but to our history, to our past responses to pandemics. Lots of research on this shows that in virtually every instance, persons who are socially marginalized bear the greatest costs of disease acquisition, of death, of rights deprivations, and of depletion of what few resources and assets they have. History also repeatedly tells us that particular groups have been identified as vectors of disease and have been scapegoated, blamed, cordoned off, and banished. So this story starts with a process concern, but it's not a concern about participation in institutionalized dispute resolution, but rather about participation by historically excluded groups, those most adversely impacted by past pandemics, in the development of pandemic plans and related legal frameworks. And these are conversations about justice, about who should have access to what resources and why, and who should bear which burdens and why. So we might consider for just a moment the benefit of access to timely and relevant communications from a trusted source. This is recognized by the Campbell Commission and lots of other work on pandemics as absolutely fundamental in the context of a pandemic. That is, access to reliable information from a trusted source. Now, differences in language, culture, reasoning processes, literacy, all point to the importance of tailored and targeted communications. But unless those with varied needs participate in developing a nuanced, contextualized appreciation of those differences, communication during a pandemic will be massively uneven, as it has been in past pandemics, with a consequent inevitable distribution of harm. Additionally, the importance of a trusted source cannot be underestimated. In fact, the Campbell Commission identified public confidence in medical information from a trusted, independent medical leader as, I underline, the most important thing in a public health emergency. But do we know who different populations rely upon and trust for information? I can tell you from the interviews we've done with homeless people, who they trust for their information may be very, very different from who you and I trust. Bound up in such conversations are significant issues about the mix of social and individual responsibility. And here too, the findings of the Campbell Commission are instructive. They point to the importance of a legal framework that makes very, very explicit and clear the kind of employment protections, for example, provided to people. They make clear the need for clarity in advance of a pandemic, of the kinds of reasonable compensation that we could anticipate if we were subjected to orders of quarantine or isolation. Its analysis underscores the reciprocity that's essential to effective pandemic responses. In fact, the Commission concludes that any fight against infectious disease depends above all upon public cooperation, which must be nurtured and promoted. Legal powers, it suggests, to compel compliance are, I quote, false hopes, not only for the homeless, but for all of us. So to what extent has this counter-narrative taken hold? Who are its storytellers? Who repeats this story? This is a story told primarily, at least to the extent I've done my research to date, by public health academics, some practitioners, and in particular those who identify as being concerned about issues of social justice. It's also a story told by the American Civil Liberties Association in a recent report. But distressingly, in a recent review of the pandemic plans of 37 countries, including Canada's, very few of these issues are identified, including the failure to identify the importance of participation of disadvantaged communities. So if we're persuaded, perhaps, that this counter-narrative is an important story to tell, how might we increase its traction? Who will be its tellers? who might constitute its audience. So in conclusion, let me return to the question of access to justice. Many of you will have heard in the telling of the second story, brief though it's been, various connections to different conceptualizations of access to justice. The importance of participation in the forms where law is constituted. The importance of that is something that Roderick MacDonald has really underscored in his work, to shift us away from a focus, a preoccupation with dispute resolution, to say participation in all of the forms, all of the realms where law is constituted, is an important dimension of access to justice. It shifts the other conceptualizations of access to justice, which shifts our attention away from access, especially access as efficiency, to focusing on justice. Again, work of Janice Grostein and Adam Cook that they did a while ago for the Law Society of Upper Canada directs us to the need to engage members of the public in conversations about justice. And that is fundamentally important, because at the end of the day, without those conversations about what justice requires, all of our systems, including our legal system, loses its legitimacy. So while I think it's fair to say that this central storyline resonates in lots of ways with non-instrumental conceptions of access to justice, in the reading I've done, I haven't come across a single reference to the language of access to justice in the telling of this counter-narrative. Maybe that doesn't matter. Maybe what's more important is simply that the ideas connected with those non-instrumental accounts or conceptions of access to justice can be deployed here to deepen and enrichen this story. And I think there's lots that can be contributed here. It may be that the phrase access to justice, which we lawyers so cherish, has little or no resonance beyond the profession. Indeed, in some other work that Professor Gavigan, Professor Siemens, and I did with youth in the Jane Finch community, access to justice had no resonance at all. And it may be that the language of access to justice is so deeply associated with the legal professional account, so deeply connected with the idea that it's all about barriers to accessing institutionalized dispute resolution, that use of that phrase may invariably lock us within the dominant narrative of national security. Thank you.
Thanks so much, Janet, and a very, I think, appropriate segue on that finishing point on what access could mean, does mean, and what it means to whom, to turn to Trevor, who is, given the hour, decided to bring us pictures in addition to words. So over to you, Trevor.
Sure. Thanks very much, Lorne. For those of you that were here this morning, you would have heard Lorne introduce the session by saying that we were going to have 4 panels of both scholarly and breezy accounts. We've now had 3.5 panels of scholarly accounts, so now I understand what you think of my scholarship. The other thing I've realized, you know, when Jamie said that I'm going to be speaking on a panel with Janet Mosher, Lorne Sossin, and Michael Trebilcock, the first thought was, what on earth can I add to whatever the 3 of them will have to say that isn't absolutely trite? And Janet has just realized my fears after the presentation that we've just had, which was just terrific, although I do think fits with some of what I want to try and do. The other thing I realized, though, is given that Rod MacDonald, Harry Arthur, Shelley Gavigan, Fred Siemens, and others would be in the House, the only conclusion I could draw is that they must have all turned Jamie down in order to make space for me, so I'm delighted that you did so. Janet started with a brief tribute to John. I'm going to end with that. And what I'm going to start with, in fact, in my paper, which is called Access to Justice, Views from the Street, is a 2-minute video, just to get us in the spirit of what I'm going to do, and then I'll come back and describe what it is that you'll see. So we're going to run that video now, if we could, and then I'll come back and describe it.
justice is ensuring that everyone gets equal rights and benefits within a country, no matter what race, gender, or sexual orientation they might have.
The basic principle of justice should be about maybe preserving what's civil in our society. It's about civility more than it is about an eye for an eye. I think people usually get the ideas crossed. I think they're homogenous.
Justice is like if someone in any circumstances should be treated fairly and equal to any other person.
Horrible. Because the rich get off and the poor don't. It's proven. You got money, what?
Like, I think some people don't even make the attempt to make a claim or sue someone because of the cost that they're going to have to bear in case they lose or something. So I think that they're way too overpriced. So if like, there could be subsidies on lawyer fees and stuff, that would be helpful.
Any problem, any case, and you take it to court, and it's going to take at least 8 months for your case to come on to the court, and then it's going to take a while for it to get to the actual process. So I don't think that is working well either.
I don't think everyone is aware of how much access they have to justice. I don't think many people know what to do or know where to go or how to act when they need to access justice.
You know, people, the public, the general public, is probably not aware of the process and the protocols that you need in order to, you know, find good lawyers or find people who are resourceful enough to educate you in what steps that you need to take.
It should be equally as important as our healthcare system itself, right? And that's just because, like, you don't know in what situation, you know, you could be needing that, or, you know, be needing that access to justice.
So what you just saw was a brief video, a collection of research vignettes, of survey vignettes, of a broader a collection that is part of a small study that we're calling What is Access to Justice? Thank you very much. Which asked a number of questions, including what is justice? What is access to justice? Is it fundamental to Canadians and the like? The premise of that little survey can be found all over the place. And we all know the premise. The place that I've put up here, because it's quick, is the statement from the Chief Justice of Canada that acknowledges that, regrettably, we do not have adequate access to justice in Canada. We know that significant reforms are needed. We know that in order to do that, understanding resistance points to change is needed. And the focus of this little study is focusing on this idea of one particular barrier, which is the idea of culture, or the culture of access. I think it resonates with Janet's second story, the first story, but this notion of the professional understanding of culture and what it might look like to change that. The little study that I want to present today, it's actually pilot findings. It's early days, and it really, I think, addresses some of the questions and challenges that Professor MacDonald put to us earlier. And what this is to go out and ask the public a number of questions. I found myself over the past couple of years saying more and more often to policymakers, lawyers, judges, those within that professional sphere, well, look, if we actually asked people on the street what they wanted, we'd get a very different story. Danny Priel actually alluded to that in his restitution paper this morning. Well, the idea is to go out and ask those people this question and see what they say, and try to drive our understanding of access from the user's perspective as opposed to the deliverer's perspective. I'll come back to that later on. But what this is not, and how I think it differentiates itself a little bit from some of the other research that this relies on, but also differentiates itself from, it's not a court exit survey or a process exit survey. It's not asking people questions that have just come out or going into a process. And it's also not a survey on what kinds of legal problems people have. That's also key for this work we're doing, but this is different. It's trying to get at the everyday perspective on what intuitively, although difficultly, is an everyday question. So what was the methodology? We tried, the video wasn't representative because it actually was mostly around York, but what we tried to do was conceptualize this around demographically relevant points in Toronto, where we actually went out and we were influenced by a relatively recent study that sort of parsed through what that might look like, to try and get a bit of a representative view of this city, to go out and do face-to-face pedestrian interviews. The response rate of our pilot study was about 25%. We did almost 300 interviews, and we were successful in actually roping in about 66 people to actually talk to us. The time frame was this past fall. We've just finished it. It was very much a collaborative effort with my colleague Sabrina Dellon, a number of our Osgoode students, etc. The context also of this, Lorne alluded to, is a broader, a bigger, deeper study that we're doing called the Cost of Justice Project that we're running through the Canadian Forum on Civil Justice here at Osgoode. And I won't go into that study other than to give you the very brief background, which it asks essentially two questions. What's the cost of delivering an effective justice system in Canada? And then the second question is, what's the cost if we don't deliver an effective justice system in Canada? And there are a number of people currently who are starting to look at that. Michael Trebilcock is one of them, and others, where we're starting to chip away, particularly at that second question and how we might think about addressing that. So that's the broader context in which this little survey forms a part. So what did we find? And essentially, what I'm going to briefly tell you from this little survey is I think we found 11 things that might be worth noting. The first, and this picks up on Janet's second story, is the everyday idea of what justice is and what access might be very much resonates in ideas of fairness, equality, and morality. When we parse through that a little bit, I think we can collect that largely into two groups. The first, which is not surprising, and I think it resonates very much with the professional understanding of access, is very much a procedural understanding of access. Secondly, however, is much more of a substantive or an outcome notion of access to justice, and I'll come to that in a minute. We also see that there is an acknowledgement that inaccessibility is not created equal. It's visited more on different groups than others, and that certainly came out in this pilot study. There is a feeling of alienation in our communities that use our services, and I think we need to recognize that. When we also put specific pointed questions to folks, we got some specific pointed answers. That justice is fundamental, that there needs to be more government support, that we should have a right to it, that it needs to be simpler, cheaper, etc. And we also got some views on prevention, and I'll get to those in a minute. And then finally, helpful for our broader project is some insights on what are the costs of not doing this. So, what I'm going to do now is touch on those various points that we found in this little survey to try and bring together what I think will hopefully help us in our pursuit of that barrier of culture that I'll end with. So when we asked the first question, and it wasn't quite this way, but largely we approached folks and said, so what is justice? And we thought this was a terrific thing to do. And of course, when we collected our initial results, we started to wonder whether we were actually off on the wrong foot, because our responses came back somewhat concerningly, shit, oh my God, shit, this is like a test, oh my God, this is terrible. So we wondered whether we were alienating people just with our questions, which of course we were, and that's part of what we found in our study. But then when we dug a little further and kept with these folks, in fact, they provided lots of very helpful stuff. So coming back to that question of what is justice, what really did resonate with folks, coming out of their statements, were these themes of fairness, equality, and morality. And now what I'm about to do is break about 17 PowerPoint rules by giving you tons of text and racing through them. But the point of the next couple of minutes isn't for you to come away and memorize the statements I've given you, But in order to do what Janet has recommended, which is to recognize the power of stories, and if we really are taking seriously the idea of the public's view, let's look at what they said. So I'm going to give you some of what they've said, and the idea of what is justice. I guess justice to me has to do with fairness. It's more than a legal issue. It's a moral issue, and it has to do with equality and inequality. What is fair and right for people? It's rights for everybody. It's equality for everybody. Being able to be an active participant in society. It's a crucial question. I think that's part of what a democratic society is all about. So I think it's big stuff that if that's the project of what we do in a justice system, I think we need to reframe a little bit what some of our procedural understandings are, and that's, of course, where we're going to. But before we skip out on procedure, of course, there were procedural understandings of what people expect from a justice system. And I don't think we need to not forget this. Ideas that access to justice is access to lawyers. It's law enforcement. It's right to a fair trial. It's fair penalty, just deserts. Everybody's ability to be heard. You do the crime, you do the time. There was an underlying crime thing going on in some of the responses, which we're still working through. But certainly there was a procedural aspect to this, which I think does fit with our traditional professional understanding of what we think of as access. I think the more challenging thing, though, for us as a legal system is to sort out how do we address the substantive stuff, what people want and expect, and I think this is where we do have some work to do. The idea that justice in the moral sense is another story, meaning another story from this procedural story we've told. I define justice as access to society, fighting for women's rights, native rights. There should be agencies that are there for constant need. We're not even talking access to justice. We're talking access to food, to shelter, to security, to opportunities for ourselves and our kids. And until we deal with that, the other stuff doesn't make sense. And if we carry on with that theme, I think there are a lot of people who don't understand what the justice system or is how to use it, struggling to earn a living, dealing with addictions. Unless we address the living conditions that they're dealing with, there really is a fundamental issue with access. The idea that there are people working 16 hours a day who have to choose between food and shelter, that's not just. And why we're not able to take care of our own population in a way that meets everybody's basic standards is beyond me. And then finally, it's just ludicrous that these bigger questions in our society are ignored. So if that's what our populations and communities are expecting from us as a justice system, I think we've got some thinking to do in terms of what do we do in this professionalized notion of justice. Next point, inaccessibility is not created equally. And I think if we have an inaccessible system, we need to acknowledge, and certainly our study has confirmed this, that there are groups who are disproportionately affected by this inaccessibility. And what does that look like? People with money have access to more justice than people without. Depends on what lawyer you can afford. If I don't have a good suit, the judge isn't going to hear me. I think that comes down to class. The higher class have more access to justice. Language, immigration, education, culture, age, sexual orientation, and you know the list. I think it depends on class, race, money, socioeconomic standing, everything. That's what we're looking at. The idea of alienation, and I made fun of those opening comments about people not really getting the question, and that, of course, is our fault, not theirs. But I think alienation cuts a lot deeper than that, and the idea and number of the responses belied that feeling of alienation from the idea of justice, let alone the system itself. I don't have much faith in lawyers in the system. I'm more of a fringe on this. The language of justice tends to be a bit foreign. I never really know anything about justice. We then, in terms of some more statistically based questions, and we did follow up with more descriptive responses, but to give you a flavor, is there a right to justice? 98% people said yes. Is it a fundamental issue for Canadians? 86% of people said yes. Should there be more government support? A slightly more nuanced answer, 67% said yes, 33% no or not sure. And then finally, when we get to this idea of what do we do about it and the understanding of simpler and cheaper, of course, people were on board with that very much. And that wasn't questions from us. We weren't saying, should it be simpler or cheaper? That was the stuff that was reflected back to us. It's very much profit-driven. Lawyers are way too expensive. I would feel like I would like a free lawyer, and then I guess maybe a more affordable one. Make the whole thing much less complex. And this is my favorite. Make it friendlier, user-friendlier. Press here. And of course, there is a press here, and we're working hard on online dispute resolution and understanding the use of technology, etc. A couple of other last observations that we got that were very helpful for us. The idea of prevention. And I think I know Michael and Lorne and others and Janet's work speak to some of these ideas of prevention, and we're working on that in our broader context. But this notion of prevention and thinking ahead of time, what can we do so that we don't get into those problems? And there's various commentators have looked at this. But what did our public say? And they had the same insights, making sure our kids are educated. Perhaps a little more of an effort can be spent on education campaigns in public school to prevent maybe heading off to jail or heading off to court or heading off to probation. Prevent it before it starts. And I think that, as we will get to, a more empowered society, a more educated society, we're going to find is part of what access to justice, I think, is going to lead us to. And then the final point that I want to notice before I conclude is this idea of cost of not making justice accessible. And of course, that's a key question for us in our cost of justice study, the broader context of this. And again, very interesting insights from the public on this. I have a family law situation that I can't afford to address. I have to just let it go. Well, that's not a costless event. We know that there are a lot of unmet legal needs out there, and by letting it go, there's a lot that underlies that, to that individual and to society as we let our legal needs go unmet. And I think that's going to be where some of the research takes us, and certainly this study has confirmed. So in conclusion, what do we draw from this sort of little race through a pilot study that I think hopefully will form part of the landscape of the work we're doing? Drawing sort of on a bit of a strange bedfellow for access to justice, the former CEO of IBM, Louis Gertner, made the following statement: "I came to see that culture isn't just one aspect of the game, it is the game." And I want to pick up on that for a minute, because I think one of the themes that we're finding, and I think it resonates with Janet's stories, which story do we tell? And I think our culture in the legal profession is very much this professionalized story of access to justice. And the idea that is coming, I think, from this study, that if we think about the voices of the user, not the provider, we need a very different story in order to make sense of what those folks are looking for. And I think it's one way to pitch it is a culture change. And there are numbers of elements of that culture change. The idea of provider to user, the focus being on the provider to the user. Back end to front end, and I'll get to that in a second. The idea from isolation to collaboration. We isolate our services so much, and there's so much more we can do collaboratively. The idea from process to outcome. We need process, but of course what people really want is the food on the table, the shelter over the roof over their head. The idea of accessibility and complex to simple. The idea from unsustainable, as our current system we know is, to more of a sustainable system. And others that I've added to this list throughout the day. The idea from formal to pluralist. And the idea from efficiency to justice. I think all of those are elements of a collective culture change in terms of how do we deliver this system. Of course, I don't have all the answers right now, and we don't have time for that, even if I did, which I don't. But I think one of the things that we're going to get to is seeing our justice system as very much an important but small aspect of a much broader notion of a system of care, of justice care, and a collaborative continuum that takes seriously that back-end emergency room view of the courthouse, but very much opens a front end of empowered citizen, educated, accessible, triage, and open-ended places for understanding and participation. So the last two things I want to say, how does this fit with our honoree, John McCamus? And of course, he's as we've heard numbers of times, has been ahead of the game on this for so often, and there's so many places to look for his views about this that have animated so many of us, including me. But I just picked up, it was sort of buried in his Access to Justice report, but of course was a theme throughout that report, and I think John's work. I've picked up some statements, but just to underline this idea of equal access to justice, focus on individuals and communities, the idea of collaboration, and a focus on fairness to justice, which I think animated the legal aid work that John has done, and all the work that is exactly what our citizens are asking us to do and that we haven't yet delivered on, but John so rightly pointed out. So where do we end? What I see is that we're the drunk guy. We've sort of been looking for our keys under the light, and we've got a good little view under the light, right? We do have a good civil justice system, a family justice system. We've got a good court system. But is it adequate? Is it accessible? And does it provide that continuum of care? Of course it doesn't. I think we need to open up that terrain for view to see what we're not looking at, and to listen to those that are using the system, and to broaden the light that we're providing these services. I'll sit down now.
Thank you, Trevor, for the words, the pictures, and the thoughts, again, which knit together both themes of the day and Janet's work in particular. Michael, do you want to come here, stay there, wherever you would like? We would benefit from your ability to give us the answers.
Thank you, Lorne. Let me begin, as almost everybody else has over the course of today and last evening, by acknowledging, emphasizing what an enormous privilege it is to be part of this wonderful event and this entirely and richly deserved tribute to John McCamus. John and I have been personal friends for over 30 years. Beyond that, a personal friendship, I've enormously admired his contributions as a scholar, a teacher, an academic leader, a law reformer, a civil libertarian, and a policy reformer on issues of access to justice. And I'm going to focus on the latter, given the nature of this session. My introduction in a serious way to access to justice issues was as a research director to John in his 1996-97 review of the legal aid system in Ontario. I've never figured out why he asked me to play this role. I suspect dubious motivations on his part as just a kind of law and economic scholar. I think he thought I might better hold the Harris government at bay. Or hold one or two members of the task force at bay, probably more realistically, that reflected views of that government. Then a decade or so on, John was commissioned by the Attorney General to do a sort of decade-out review of how the reforms had unfolded over the intervening decade, but shortly after he began the review, the Attorney General appointed him chair of LAO, so John felt he shouldn't be reviewing his own agency, and suggested to the Attorney General that I take over the review. So my entire involvement in the Access to Justice enterprise is driven by John's kindness in involving me as a collaborator with him. Now, I think that the two papers presented in this session on their face seem rather dissimilar. Janet's focused very much on, I think, this very provocative set of issues raised with respect to the disproportionate risks borne by socially marginalized segments of the population from measures taken or proposed to reduce the health risks associated with pandemics, and Trevor's this series of vignettes from the street. But in fact, I think some important common themes emerge from the two papers and from other recent work which suggest some important new directions in thinking about access to justice. I've grouped these under the general heading, the end of the court and lawyer-centric paradigm of access to justice. So I'm going to make 4 or 5 points quickly. First, as various civil justice needs surveys in Canada and a number of other countries in recent years have revealed, maybe with the exception of the criminal justice system, with which, after all, only a tiny percentage of the population ever becomes directly involved in, many of the problems that ordinary citizens encounter in their daily lives have very little to do with legal rights, formal legal rights effectively justiciable through the court system, which might be taken to imply a central role for lawyers as advocates in asserting these rights. Just let me comment briefly on 3 areas of concern that emerge from these civil needs surveys of citizens. Family law, employment law, and consumer data creditor law. Many of these civil needs surveys identify these as areas of high problem intensity or incidence. Well, in family law, much current thinking favors diversion strategies out of the formal court system and into various forms of front-end mediation or ADR, in which lawyers play a rather limited role. Second area, employment law in non-unionized sectors. Non-compliance by employers and meeting wage obligations, overtime obligations, benefit obligations. And in Ontario, the Employment Standards Act typically involve employees bringing individual complaints to an administrative tribunal. This has proven extremely ineffective, I think, in terms of costs and delay. And instead, there's much to be said, I think, and others think, for a strengthened role for public enforcement through a much more regular system of inspections of significant workplaces of the kind that occurs with respect to occupational health and safety issues. But again, we're not talking individuals any longer enforcing entitlements in the formal legal system. Take the third area, consumer protection data creditor concerns. Here, a tiny percentage of consumer or data complaints end up in the formal court system and are typically resolved, if they are resolved at all, through various informal or administrative mechanisms. Now, if you broaden, one broadens one's horizons further to include matters such as housing concerns, access to social benefits, workers' comp concerns, access to other government entitlements. We find that citizens are typically embroiled with various arms of the government bureaucracy or administrative agencies or tribunals attached thereto. But notice the courts and lawyers are really not a central part of any of these stories. So the one-size-fits-all paradigm, what I'm calling the court lawyer-centric conception of access to justice, I think is fundamentally undermined by this increasing body of empirical evidence of the nature of the concerns that citizens encounter in their daily lives and the kinds of mechanisms that they typically have recourse to address them. And I think implies a much more pluralistic set of access to justice strategies than this kind of one-size-fits-all paradigm that has dominated post-war thinking here and elsewhere in access to justice policy circles. That's my first and most major point. Second, and it's a point very much related to the first point, in these surveys and focus groups and the like, which is really justice from the ground up, or from the street level, as Trevor would put it, very few citizens draw sharp distinctions in categorizing or characterizing problems or concerns as legal on the one hand or non-legal on the other. They're just concerns, they're grievances, they're problems. problems with government or its agencies or large bureaucracies in the corporate sectors. For them, problems are problems, however they're characterized. So I think the idea that we can compartmentalize problems, it really does not at all track the way average citizens think about problems. Third, in terms of what to do about problems, however characterized, even if lawyers' services were costless, even if they were costless, it seems clear that in many of these problem areas, lawyers are not the most effective interlocutors, either in providing advice or representation proactively or preventatively, or in remedial action after the fact. Many of the problems areas that I've briefly identified that citizens encounter frequently in their daily lives are not areas where lawyers, for the most part, have any specialized expertise, because they're areas that are largely unprofitable for the private part of service. And a wide range of other types of interlocutors may be able to offer more timely and relevant assistance, from social workers or counselors in the family law area, financial advisors in the debtor creditor or again family law area, paralegals, volunteer lay advisors with specialized expertise that play a prominent role in the UK Citizens Advice Bureau. But given that lawyer services are not costless, whether privately retained or funded through government programs such as legal aid, it's clear that in many contexts they're not remotely a cost-effective response to many of these classes of problems. My fourth point would be, as I think both Janet's and Trevor's papers underscore, in many contexts, proactive rather than reactive policies much more effectively address the source of the problems in question. And here, Lorne and Tony and I in the Middle Income Access to Justice book borrow a metaphor, I think originally developed by Richard Sossin, of a community facing two strategic options in dealing with people who are killed or injured in falling over a steep cliff abutting their community, right? So one strategy would be to put a fence at the top of the cliff. Another strategy would be to expand emergency services at the bottom of the cliff to pick up and deal with the broken bodies. I think the way we have conceived the access to justice system, for the most part, over the post-war period, is very much the emergency service, ambulance service kind of conception of how to deal with problems. But as in many problem areas, and Janet has identified one, but Ian Ramsey and Tony Duggan and a paper in the Middle Income Access to Justice book explore similar strategies at great length in the consumer debtor creditor area. The preemptive strategies are often readily available, just like the fence at the top of the cliff. And here, I think the legal aid community, by focusing on the ambulance model of access to justice, has devoted far too little attention to the fence building model of access to justice. Perhaps because there's less money in it. That would be the more cynical explanation, or a less cynical one is simply myopia. So for all these reasons, I sympathize with the dominant themes in the two papers presented here this afternoon, at least in the personal household problem context, as opposed to the business context. I think the post-war court lawyer-centric paradigm of access to justice, with the notable exception of the criminal justice system, has been increasingly revealed by recent empirical evidence to be a castle largely built on sand. Thank you.
Thank you very much, Michael. The only area we actually really struggle with that metaphor, although we all live our lives trying to solve it, is family law. How to get people to love each other and stay together is actually a bit of a greater challenge than you might think. But it shows, I think, the metaphor, how often, for one reason or the other, we tend to focus on courts and lawyers, and I think we've heard wonderfully in this panel, but also from Rod and others today, just how broad access to justice a concept is, and I think we hearken back to the work of John in inspiring a lot of these deeper questions about the meaning of access and how to ensure there is a way forward that is progressive and just. So with that thought, we have time for just a question or two before we continue the discussion over beverages in a brief reception afterwards. So I'll keep us to time, but Raj, Anand, the floor is yours. The elusive search for love, or the other part?
The lawyer-centric part, as opposed to the public narrative. I mean, Janet's and Trevor's presentations, I think both were sort of a story of two competing narratives. And to be frank, I think I understood Janet's narrative. I understood Trevor's competing narratives a bit less, at least if what was being put forward is that they're in competition. That is, on the one side, the efficiency and effectiveness of the lawyer-driven institutional processes, and on the other side, the public priorities as revealed in the surveys that you've done of substantive justice and fairness. And it seems to me that the two aren't really in competition in terms of where we should be focusing our attention so much as one is the end and the other is the means. And so I would say that they're not really a choice of two mutually exclusive alternatives, or a situation in which we should be focusing on one or putting our resources into one as opposed to the other. It's really both, because I would say that attacking the problems of the courts, that courts, tribunals, lawyers, we traditionally focus on by looking at the institutions that we have in place is necessary, but at the same time clearly ask ourselves whether, even if the barriers that we so readily identify as lawyers were eliminated or at least reduced, whether the systems that we've put in place in specific areas of law would indeed serve those needs of substantive fairness and justice, even if all our lawyer-driven problems were miraculously solved or removed. And so I guess, to put it in the jargon which I hesitate to use because I don't understand it, it's really the software rather than the hardware that we need to be, I think, focusing on more. But I would say this, that I don't think it's a matter that we can dismiss the lawyers' problems and simply focus on what I'm simplistically characterizing as the public's problems, because I think they're both complementary, and it's really a matter of institutional design as much as issues of mechanics of hardware.
Trevor, do you want to respond, and then we can ask Janet or Michael?
Sure. Raj, thank you for that. And I'll be quick because others will have. I agree and I disagree. I agree that the current system is a step in the service of justice, if you will. I agree with that. I also would say that it's a necessary part of that step to justice, but far from a sufficient step to justice. And I think where the gap is, and I'm simplifying for purposes of the conversation, but I think we are pouring essentially an overwhelming amount of resources in our current hardware. And that hardware, even if we give it in its best face, even if it will be working perfectly, it's far from sufficient to address the kinds of stuff that people actually want. So in the Richard Sossin point, that I think we often look at the fence at the top and the ambulance at the bottom, one of the things that doesn't give us is that there is going to be conflict at the society. People do want to get down to the bottom, or will get down to the bottom somehow, And one way is an emergency room or an ambulance. Another way is to help people understand how to navigate to get down, how to empower people to work through that climb down or climb back up. And I think that's where our current system is necessary but insufficient.
Janet, any other thoughts?
Maybe just to take this in a slightly different direction, I guess one of the things that I struggle with around this idea of the dominant narrative is really trying to find a way to displace the dominant national security narrative, which I think in some way predetermines the outcomes in relation to how we think about individual rights and access to justice. So partly what I'm struggling with is trying to find a way in which we could more effectively challenge that dominant narrative. Again, because I think that narrative itself presupposes the outcomes, as I tried to explain earlier. And so as I was working on this, I've been trying to think about, well, does access to justice itself give us a language, a set of conceptual tools or ideas that could help create a powerful counter-narrative? And so in one way, I see the access to justice language actually fueling the national security narrative. At best, it provides some modest checks on the exercise of state power, but not very effective. And so I was struggling in trying to think about that second story is, can other conceptualizations of access to justice help us to create a more powerful counter-narrative or a narrative that gives us more traction? And where I am right now in thinking about that is, doesn't really do it. But then thinking about, well, how could we construct a more powerful narrative? If we think that first one, the national security paradigm and public health as national security, is a deeply troublesome narrative, and I think it is, how do we begin to think about the ways in which we can displace it? And so that's kind of where I'm stuck.
Michael, do you want to try to get us unstuck?
No, not at this hour of the afternoon. Just one thought, a slightly perverse thought. Even if one were to adopt an ambulance model conception of access to justice, and I accept Raz's point, it's not a sharp either or, the fence or the ambulance service. Some people are going to fall over the cliff even with a fence, right? So we're going to need some ambulance services. But in many of the contexts that I was speaking about, even with just in the ambulance category, it would be crazy to have the ambulances staffed only by doctors. In fact, we don't see that, right? We don't send ambulances around to accident sites staffed by doctors, but that's the way we've conceived, for the most part, of the ambulance service in access to justice or legal aid. I realize there's paralegals and so on. Yeah, but what a fight to get even a modest role for paralegals in this province, right? And even then it's a limited role. And there's still hostility to assigning any kind of significant role for volunteers in providing legal advice of the kind they freely do in the UK in these citizens' advice bureaus, non-lawyer, but this is the unauthorized practice of law. But this is tantamount to insisting that every ambulance be staffed only by doctors. This is, I'm a law and economics scholar. I'm saying, this is crazy, right? We ran the healthcare system that way. We'd be outraged, right? But that's the way we run the back end, right? The accident end or the emergency end of the access to justice system. So this is before we even get to talking about how many fences there should be or how high they should be or whether we could build a fence in family law. I haven't thought of one, but other areas of law I think are much more conducive to fences than family law.
No, and let me finish with a last thought on the outrage point, and then we'll carry this conversation over where it belongs in a more convivial space. But all this discussion also assumes a kind of static understanding, like we know what lawyers are. We know what that model is. It doesn't change, and it's the alternatives to it that are progressive and more expansive and able to do all these different things, but it gives me a chance to bring us back to a place where John's whole career has been, but ironically hasn't been the subject of a panel, and that's legal education, right? We have the lawyers that we create. It's not that they're simply out there as this, external thing about which we then try to find better and more progressive alternatives. It can be the better, more progressive alternative. There's no reason we couldn't have fence building, in other words, as what the law school is about, or the storytelling as what legal education is built around, and the critical approach to the stories we tell defining the policies we get. And I think so much of the inspiration John's provided over the years has been in the classroom to think critically and not accept as gospel what we find in cases, statute books, the vision of governmental services, which is actually why we have doctors in too many ambulances. It's not because that's the better outcome for the people who are hurt. It's that we work in these silos, governments fund in those silos, and so we look for solutions in those silos. And it doesn't have to be that way. And I think a theme today has been looking at some of the observed realities with that lens on how it could and should be different. And that was certainly a theme in this panel, which I very much enjoyed. And I know there's some other comments and discussions that one would want to have, that we will have, but we're probably at that time to make that shift. And I'm looking at Jamie for guidance as to where we're going to go. Just next door? Just out here, and then filling the hall. And the snow, as I said, provides a very compelling visual backdrop. It shouldn't be of any concern. But lastly, let me again thank the sponsors for the symposium, thank all the speakers, including the wonderful three on this panel. Thank those who have weathered the storm, so to speak, here to the end. And of course, look forward to the written product of all this labor and the memories of the day, and of course the ongoing contributions of John to our community, which remain very much works in progress that I look forward to being around to see unfold for years to come. So with that, let me bring the formal proceedings to a close. Thanks again to all of you.
Well,